Hello and welcome to our Spotlight videos where we discuss cutting-edge employment law issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, a firm that helps people who've been fired or afraid that they might be. I'm thrilled today to be joined by Tyler, who is a second-year law student who works in our office and has been doing some fantastic work for us. And Tyler, I think we are going to be talking about the exciting topic of fiduciary duty of loyalty. I'm only half kidding. It's a lawyerly kind of topic, but it does come up a lot in employment law. So what do we need to know about that?
So Tom, I'm going to try to break this down in pretty simple terms because you're right. The fiduciary duty of loyalty is very lawyerly in its title. But essentially what that means is that in Virginia, employees must act loyal to their employers and not commit competitive acts during their employment. Now, employees do have a right to arrangement, which is in preparation of termination or resignation. They can make plans to arrange how they're going to be afterwards, but they can't compete with their employer. Now, that fine and fuzzy line between competition and preparation is very fact-based in Virginia, and usually the interests that are being balanced is a desire for a competitive marketplace on one hand, and on the other hand, you want to have an integrity and fairness relationship with their employer and employee.
Right. Yeah, and I think it comes up a lot in Virginia, mostly when employers are mad and they're threatening to countersue, they're threatening, a breach of fiduciary duty of loyalty, which essentially means, you can't do anything while you're at your employer. You could potentially be liable under this theory if you do something to damage your employer while you are still employed there. And as you say, look, if you're getting ready to leave the company, or if you've been fired, you got a right to look for another job. We will see employers try to use this often as a counterattack. It's hard to be successful for the employer. A lot of times it's a lot of saber rattling, but there are some cases where people have been found liable under this act that can result in you having to pay money to your employer. So, and it also is like there's an overlap with the issues of non-competes, right? If you've signed a non-compete, which is a contractual, a contractual arrangement versus fiduciary duty of loyalty, which again, to use our lawyerly terms, is a common law duty that you owe to your employer.
Yeah, and actually, Virginia courts have 3 examples of what would be considered a competitive act. Obviously, this list is not inclusive. There's other options, but that includes misappropriating trade secrets, the misuse of confidential information, and soliciting an employer's clients or other employees prior to termination. There's actually a recent case in Virginia that was decided that said when a coordinated resignation of multiple key management personnel that resulted in the loss of half of that employer's business was an actionable breach of fiduciary duty on those employees. So just something to look out in as you prepare to leave a job or anything else under those terms, just to make sure that you're doing everything in a very tight, neat way that doesn't overstep that line into competing.
Yeah, and as those kind of examples show, if you are violating that, even if you don't know what the concept means, you probably know it, right? This isn't usually inadvertent. When you've got a coordinated resignation among key management officials, there's been some conversations before this. So it's not something you usually step into accidentally. And as those examples show, there's often overlap with other statutes and common law and contractual provisions, again, like non-solicitation provisions, or in many kinds of employment agreements where, if you kind of are asking people to, you're trying to take people with you on the way out the door, that can be a breach of non-solicitation, also a breach of your duty of loyalty. So often you'll see employers throwing, That's count 3 of the counterclaim. The counterclaim, right? They've got the violation of the non-compete, violation of non-solicitation, and breach of the duty of loyalty. So, again, it's not something that you're probably going to fall into accidentally. It's when people take affirmative actions to kind of hurt their employer. And as always, if you're getting ready to leave a job and you're worried about this, schedule a consultation with a lawyer, an employment lawyer, and go through this and make sure that your nose is clean before you leave. So, but it is an important topic, and we do see employers roll it out most often as counterclaims after an employee has sued. But sometimes we will see them take affirmative action, like in the cases that you mentioned. So, anything else on this, Tyler, before we call today?
I got nothing else really. I'm all
okay,
good.
Great. Well, I appreciate it. This was a very important topic, sort of a sleeper that a lot of people are not aware of, but it's important because you can get snake bit by it if you're not careful. So thanks again, Tyler, for that one. And we wish everybody good luck out there.
Thank you, guys.